Good morning, friends. Today we are going to have the lecture on tort law, due care, and hand rule. So far, we are actually talked about different liability as well as negligence rule, which deal with the kind of compensation as well as the activity level vis-a-vis the precaution level under these rules and the behavior of different players under this rule and whether they are going to take a due care or not or what kind of activity they are having or not was the concern in the earlier lectures. However, today the 15th lecture is focusing on how the standard of care is being set. So we are going to talk about the initial development of this and the legal setting of standard of care. So let's have a kind of a proposition. We have been assuming xn is equal to x star, which is already the standard understanding. That is, the due care level is equal to the optimum level of care. So court could set legal standard for avoiding negligence equal to efficient level of precaution, but in some cases this is what court actually try to do. That is called the Hans rule. But the why the xn is equal to x star is xn is equal to x star is a theoretical possibility which we see that is the best thing. But how real world situation is basically aware of all this thing is a very practical problem. So since that is there, if a case comes in front of the court, how that been resolved by the court or the judicial setting of the standard of care a priori to the case, etc., are the matter of concern. So in that regard, hand rule is being probably applies in most of the cases in that sense. So especially in the US versus Carroll Towing Company, 1947 cases, US Court of Appeal had a case which was being dealt by Judge Lan Hunt. So from the case is the following. The Carroll Towing Company is a towing company of boats in the decks. So several barges accused together to piers. Defendant's tugboat was hired to tow one out to harbor. So crew readjusted lines to free barge. Adjustment done incorrectly. One barge broke loose. So it collided with the ship and the ship sank. So this is what is actually the situation. And barge owner sued tugboat owner saying his employees were negligent, and the tugboat owner claimed barge owner was also negligent for not having an agent on board the barge to help. So this is what is actually a corresponding mutual response of to the sue. So the but both the barge owner as well as the tug had talked about the negligence rule. So the question is that was it negligent to not have a bargee on board? So this is the question. Some employee has to be there in the barge is the concern of the tugboat owners, but at the same time, the negligence of the tugboat owners too being questioned. Where the question of whether we need to have a person on board. So to deal with this thing. So Judge Hunt in Carroll Towing decision made the following observation that it appears that there is no general rules so far, as we have already seen in the contract and all. Normally we see that the default rule plays and all. But here he himself in that sense said that there is no a priori rule exist in this case, and since there are occasions when every vessel will break away from her moorings, and since if she does, she becomes a menace to those around her, the owner's duty to provide against resulting injury is a function of three variables. So now the owner's duties depends on the probability that she will break away, the gravity of the result of injury if she does, and the burden of adequate precaution. So these are the three things which everyone has to keep in mind. Perhaps it serves to bring this notion into relief to state it in an algebraic term, that is the probability be called P, the injury called L, and the burden is called B. So liability dependent upon B is less than L multiplied by P is liability. Okay. So Hand's rule precaution is required to avoid negligence if and only if cost of precaution is less than reduction in accident time size of accident. So we have already applied this rule in our earlier case and found out what is actually the efficient level of activity, and whether the people are going to have an efficient level of activity or efficient level of precaution, etc. And this is the fundamental uh, idea behind that. And so having not having a baji is discontinuous, that is yes or no. But if precautions were a continuous variable, we could think of this as marginal cost and benefit. So this is a very straight and sharp point which he was trying to argue. That is, when somebody says that the precaution is necessary, because every company has to foresee what is going to actually they are going to inflict upon others, the cost that they are going to inflict upon others. If they cannot, then they have the responsibility of this cost, right? So having not, and then particularly if they are having a barge or not is a different question, but they should know at least that if there is a problem they are responsible in it. So because there is always a cost involved in that, but if precaution were therefore continuous variable, we could think of these as a marginal cost or benefit. So cost is W, that as we said, marginal cost of precaution is W, then reduction in accident is equal to an inverse of P time X. That's what we said. So size of the accident in that sense is A, and hand rule says if W is less than minus P X time A, then you were negligent because more precaution would have been efficient in that context. Okay. So how is legal standard of negligence established? One way, that is successive application of a hand rule, is one of the example. Another one is actually a laws and regulations can specify legal standard. Now the question is that now you have a formula of hand, learn hand, who developed or who just placed in front of the case, that is in by as a judgment he was making this observation, then later that become a standard rule in tort case. And if you have that rule, it is easy to understand or kind of evaluate from the perspective or the legal standard of care. But at the same time, the court also can actually a priori set or the government can actually bring in laws or regulations which can specify legal standard of care. And then we also have a situation that is law can enforce social norm or industry best practices. And this is also very important, not necessarily by law, but people may do if Arrow said that as learning by doing is the greatest kind of information and or understanding the situation better. People learn in their due course. Some actions are very efficient for some particular thing. So if that is actually being found out, then these are called the best practices. So we can actually rely upon best practices and ask for people to behave accordingly. So two difficulties in establishing legal standard of care from this, even though the points are being set up, that is, the American courts have misapplied hand rule very often. Okay, that is, to calculate the efficient level of precaution, reduction in harm should be based on total social cost of an accident. Now, this is a very important point which we need to keep in mind. So far, what we have said is actually the cost is not private always. Okay, especially if it is involved with the other parties or some people. Maybe you cannot actually immediately count the people. There are many issues which is comes in front of the court are most general problem. It will always have a cost on others. Not only the one party who sued is having this issue, but there are many other people also having the same issue. So this is what is called the socialist on one angle, and at the same time the social cost has to be assessed because it is going to have a lot of problem. Now sinking the ship is maybe a loss for one party, but at the same time this is going to actually cost a huge damage in the port. At the same time it will also inflict cost upon the docking and other issues. Okay, so because it may also um, the remains of the shipwreck is also going to create a lot of problem in that sense. So the cost which is basically is social rather than one particular individual's loss per se. So that has to be evaluated. So should include harm to victim, that is risk to others, and to injurer himself, that is risk to self. So this is what is actually missing in most of the time. So risk to others and risk to self has to be assessed. Then only it would be assessed the social cost. Otherwise, it is not. So courts have tended to only count risk to others when calculating benefit of precaution. So then there is also an issue of hindsight bias. That is, after something happened, we assume it is likely to occur. So if there is an incident happen, then we feel that okay, it's supposed to happen. So an incident is actually a result of so many issues. So that has to be evaluated because hard to get unbiased estimate of probability after something happens, likely to overestimate in that sense. So the overestimation problem and the problem of social cost calculations are the most important problem with this understanding. So as far as this is the case, this is normally being come up as a criticism of what is in the American courts do with this, but doesn't mean that it is universally the case. There are many cases which is having a far more insightful judgment, which is we kept referring in the lectures. So strict liability versus negligence as information and dissemination. So let's talk about that portion. So relatively easy to prove harm and causation. So in that, but it is difficult to have harder to prove negligence. So this is another practical problem which is normally encountered by. See, we have already seen that in the accident cases you have three issues to be dealt with, especially when you talk about negligence, care level. But in the strict liability case, never asks anything. The third, that is, we know that there is a harm and then there is a cause. Now, if that cause and harm is obvious thing, then liability automatically falls upon, and then you can very plainly just not plainly, relatively less complicated to give a sort of judgment or observation or whatever. But at the same time, if it is a negligence case, we have already mentioned about this problem difficulty. Now it comes with a very different issue of proving it, because what is the level of care? If negligence is hard enough to prove, injurers might avoid liability altogether. This is an issue, and in which case they have no incentive to take precaution. So negligence requires me to figure out the efficient level of care for Coca-Cola. Strict liability only requires Coca-Cola to figure out the efficient level of care. So this is having actually two different issues. So if you say that if negligence and it is my responsibility to prove that they are negligent, I am not. It is quite different, because and not only different, difficult, literally impossible in that sense. The Coca-Cola example is a classic one. So suppose who is responsible the additional extraction of water in Kerala, because the Coca-Cola stay and everything, there's a struggle, community struggle, and it becomes a huge hue and cry in the state in the 21st century, the beginning of the 21st century, because of so many problems, right? And it is interesting to observe many of the court orders regarding this matter, and there are not order, sorry, court's observation in this matter. And the negligence and other stuff, though we don't actually having a sort of a tortious law system in a very strong manner, just like the United States, but still, the observations are quite interesting in that sense, because they have to prove that this company had basically created ruckus or a sort of havoc in their environment. And if but at the same time, if it is applied strict liability, that is, if you over exploit water, then definitely you have to pay this much. Things are simple, and Coca-Cola has to, then Coca-Cola, by as a company, they themselves know that how much water or whatever things which they are going to extract is in their knowledge, not the people's knowledge. Therefore, the that kind of a liability rule is more efficient to understand the efficient level of care as far as the company is concerned than the other things, but it never happens. So this is a problem. So effect of, now let's talk about the effect of errors and uncertainty and strict liability. Okay, now as I said, strict liability is better in the Coca-Cola case, but doesn't mean that it is always better in every case. All right. So strict liability rule. Let us talk about the other possible. The injurer minimizes Wx plus Pxd. This is what we have said, right? Perfect compensation, that is D is equal to A. So leads injurer to minimize social cost, which is Wx plus Pxa. So under strict liability, random errors in damage have no effect on incentive. All right. That is given the fact that the errors in damage have no effect. Random errors have no effect on incentive. So injurer only cause about expected level of damage in that sense. So only cares about the expected level of damage. As long as damages are right on average, injurers still internalize cost of accident set efficient level of precaution and activity, but otherwise they cannot, and then things are going to be very bad in that situation. So let us understand that is in a diagrammatic format. Effect of errors and uncertainty in the strict liability. That's it. So this is, we have already seen, that is Pxa and Wx. So your cost and this is, if your precaution level goes up, then the total things will fall, and naturally you have a Wx plus Pxa. So this is what is your extra, which is the minimum, the efficient level of care. If you take efficient level of care, but what happens? Vxd, the perfect compensation case, this is the case. So in the in the other case, if your this is shifts down, then things are going to be different. Then your x is actually is less than what is x star means. So under strict liability, random errors in setting damage have no effect, and systematic errors in setting damage will skew the injurer's incentive. So if damages are set too low, precaution will be inefficiently low. If damages are set too high, precaution will be inefficiently high. So these are the trade-off which we have to keep in mind. So failure to consistently hold injurer's liability has the same effect as systematic setting damage too low. So if not all injurers are held liable, precaution will be inefficiently low in that context. So this is what is the case. So in that case there is a gap between it, and this is the exact level. So if you what about negligence rule? This is the case. So under negligence rule, a small error in damage have no effect on an injurer's precaution. This is what is the advantage of that. So under the xn is equal to the standard of care is, then you have this difference, right? So if this is an over case, so under negligence rule, injurer's precaution responds exactly to the systematic errors in setting the legal standard. So that's it. So x star, if you this is there, if there is an error, then there is always an under understanding or over reliance or kind of. Under a negligence to random error in the legal standard of care leads increased injurer's precaution. This is the result. To sum up this effect of the errors and uncertainty, let's talk the under strict liability. You have random errors in the setting damage have no effect. Alright? But systematic errors in setting damages will skew the injurer's incentive in the same direction. Failure to consistently hold injurers liable lead to less precaution. Under a negligence rule, small errors, random or systematic in setting damage have no effect. Systematic error in the legal standard of care have a one-to-one effect on precaution. Random errors in the legal standard of care leads to more precaution. So when court can assess damage more accurately than standard of care, strict liability is better. So when court can better assess standard, negligence is the better rule. Therefore, when standard of care is vague, court should err on side of leniency. So these are the understanding from this thing, and then we have other problems like comparative negligence, evidentiary uncertainty issues. So evidentiary uncertainty is given a legal standard for negligence xn and an actual level of precaution taken x, still uncertainty in whether the court will find negligence or not. So evidentiary uncertainty is like random error in setting xn leads to over precaution, but comparative negligence partly mitigate this problem. So these are the issues which normally we all. Any negligence rule, if you have, then your x star is equal to setting this thing. So simple negligence, evidentiary uncertainty case and all, you have this thing, blue line. Comparative negligence, you have again less than that. So comparative negligence mitigates the effects of evidentiary uncertainty in that context. So there are many studies which is actually talked about this thing, and tort is a area where you have largely different a lot of study, different and diverse studies have been done, and a lot of applications been developed, and many rules which just talks about the complete characterization, etc. and all. So this is mostly a very developed area to deal with, and why people move one rule, or why you stick upon one rule in one place than the other rule, etc. So, with this note, let us conclude this session, and I hope all of you understood as well as enjoyed the lecture. Thanks once again for listening me. Thank you so much.